welcome to today's webcast. I'm Mark Hirsch, a non-attorney spokesperson with Palachik, Boheme, and Wilkowski. Today, we're talking about the E-2 investor visa, what it is, who it's for, and what people need to know before they invest time or money. Before we get underway, please note this presentation is for informational purposes only. It does not constitute legal advice. I'm joined by Mary Wilkowski, partner at Palachik, Boheme, and Wilkowski. Mary has spent over a decade helping entrepreneurs and investors navigate U.S. immigration, including structuring and securing E-2 investor visas. Mary, thank you for joining us today.
Great. Thanks so much. Happy to be here.
Wonderful. Well, Mary, let's start simple. Who is actually eligible for an E-2 visa, and how important is it whether your country has a treaty with the U.S. or not?
Thank you, Mark. Yes, it's critical that your country has a treaty with the United States in order to qualify for an E-2 visa. An E-2 visa is based strictly on nationalities between countries that have reciprocation between the U.S. And their home country. So individuals need a passport from the country that qualifies. The common examples that we work with on a regular basis are citizens of Canada, Mexico, Spain, France, Germany, Italy, Turkey, Argentina, and Japan. So if an individual has a passport or a nationality or citizenship from those common countries, or other countries that have maybe less common applicants but have qualifying treatment, they can apply for an E-2 visa.
Okay, so once someone knows that they're eligible, the next thing that people get confused about is how the visa actually works in practice. Could you explain the difference between an E-2 visa and E-2 status, and how long someone can stay, and whether there are limits on renewals?
No problem. So there's generally no limits on renewals for either option. We've had people that have been on E-2 visas or E-2 status for several years. Usually renewal eligibility depends on how good the business is doing and whether the person still qualifies to meet the eligibility requirements. The key difference between visas and status are that an E-2 visa is actually issued by a consulate or an embassy abroad in the individual's home country. An E-2 visa has the luxury of being able to travel in and out of the United States during the validity period of the visa. Depending on someone's nationality, the E-2 visas are usually valid from anywhere from 2 to 5 years. And so having the visa being issued by the consulate or the embassy allows the person to travel in and out of the United States during the validity period of the visa. So it's very common and attractive. People come to the US to run their business, and then they'd like to go home for summer vacation or Christmas vacation, things like that. And with the visa, they would be allowed to do that. The E-2 status is for someone who's already in the United States. For example, in another status or E-2 status already, they can apply, if they don't wish to travel, they can apply for E-2 extensions or E-2 change of status applications from within the US. Upon approval, that status is only valid for 2 years and can be renewed every 2 years, so long as the business continues to qualify. But that status does not allow for international travel. That status is only valid so long as the person remains in the United States. So usually the difference between the two comes down to personal preference for people that wish to travel, or qualifying risks of it going back to their home country during times where maybe the consulates are busy, there's not a lot of visa appointments, so it's really not a great time to go back to the home country. They need to file here first and then maybe go pick up the visa at a later date. So two separate processes that don't necessarily coincide with each other and are not necessarily appropriate for every individual. And so individuals will make that determination on a case-by-case basis for them.
Got it. That helps frame the structure. Now let's talk about the part that everybody's probably thinking about: money. Is there a minimum investment, and what do officers actually expect in practice?
So there's no required minimum. There's no number listed in any of the regulations or foreign affairs manual, which guarantees anybody to qualify or not qualify. The key to success for an E-2 visa is the money, regardless of the amount, the money needs to be fully spent or committed on a venture in the United States that's going to benefit the US economy, things like job creation, tax payments, things like that. The higher the level of investment, the more likely chance of visa issuance, because it shows a greater commitment on the individual's willingness to invest in the US, come spend money here, provide jobs here, and really help the U.S. Local economy. In practice, on a regular basis, we like to see a minimum investment of about 120,000. Some consulates like to see higher levels. Those are very few, and those are more consular specific. But in practice, a good healthy budget would be about 120,000 or higher.
And tied closely to that, there's this phrase people hear all the time that isn't always well explained. So when people hear that the funds must be at risk, what does that actually mean in real terms?
So at risk means that the funds have actually been spent, that money has actually gone out the door. The individual has actually spent money and committed money on items in the United States. So for example, inventory purchased if they're an inventory-based business, lease deposits to show that they've committed to their lease premises or their warehouse premises. Asset purchases, for example, if you purchase a restaurant or things like that, you've purchased the equipment to set it up, you've done the renovations to the property, you've purchased the chairs and tables and things. Other expenses that they like to see, certain marketing expenses. Have you built a website? Have you started to market your business? Is the business ready to be open? So an E-2 visa is very attractive. If you've spent the funds, you have a high chance of success. What the consulate doesn't want to see is they don't want to see just $120,000 worth of cash sitting in a corporate bank account or a personal bank account in the United States. There's no concept or an idea where you can tell the consulate, say, I will go spend that money if you give me my E-2 visa. The consulate's will only issue the visa if that money has been spent, or for example, put in an escrow account for the asset purchase of a company or things like that. So they want to see a level of commitment from the individual directly, that if the visa is not issued, the person will have lost some money. That's where the at-risk part comes into play, is if you don't get your E-2 visa, have you already spent money in the United States? That's the level of commitment that they want to see.
That makes sense. Now, there is a big follow-up. We hear this all the time around where the money can actually come from. Can the investment come from a gift or a loan? And what needs to be documented so that it's acceptable?
Great question. In terms of documentation, usually the consulate will accept bank statements, promissory notes, wire transfers, savings accounts, things like that. Everything, it's hard to document cash payments or cash transfers for obvious reasons. So wire transfers, usually major banks in all countries would have records of that and can provide those records appropriately. In terms of source of funds, gifts or loans do qualify. So for example, you could be given a gift from your parents, for example, or a loan from your in-laws, something like that, to come up with the cash to make the investment. Other sources of funds that we have seen on a regular basis, certainly people's savings accounts, that maybe they've been employed or been a professional in their home country for several years, run businesses in their home country for several years. So they have a significant amount of savings, and now they want to take that cash and put it towards a venture in the United States. We've also seen inheritance. They inherit some money from a family member or a friend, things like that, that they now want to put towards a venture in the United States. They've sold properties. We've seen the sale of property. Corporate distributions, other ways to do it. You could, for example, if you didn't want to sell your property in your home country, if you took out a personal mortgage or a line of credit, for example, in your home country, maybe against a personal assets or a personal property, you can use those funds to invest towards your venture in the United States. There is a key, if you use any type of security interest, such as a mortgage or a promissory note or a loan from a friend or family, there is a key point that the loan cannot be secured by any assets of the E-2 company. So you can have it secured by personal assets, for example, your home, But if the promissory note or the loan is secured by any assets of the E2 company, then that loan would not qualify. So that usually comes up in the context of the purchase of a new company. They have a promissory note that they've granted to the seller of a business, and the seller will secure that promissory note with the assets of the company over the course of the 5-year payout of the promissory note. So if the assets are secured by the E2 company, it does require additional analysis and does usually require additional cash payments because the value of that promissory note would not count towards the investment.
Yeah, that makes sense. And once those funds are in place, really the next question becomes how the business itself is structured. How much of the company does the investor need to own? And can they have partners? Can they have outside investors?
Yeah, so usually an investor needs to own at least 50% of the U.S. company. There is a requirement that if there are partners or multiple ownership interests, several investors, for example, or several partners, then 50% of the company must be owned by a citizen or national of the treaty country who is not also a U.S. citizen or green card holder of the United States. So if they're partners, if they have multiple partners, they still need to meet the 50% threshold that the company is owned by citizens of the treaty country that are not also U.S. citizens or green card holders of the United States. So you could have someone who, for example, is Italian, be a U.S. citizen as well, if that person owns 50% of the business and the Italian who's not a U.S. citizen owns 50% of the business, that investment will qualify. If there's another Italian is also a U.S. citizen and they own 33, 33, 33, that investment no longer qualifies because now you have a 33% ownership interest by someone who's not a U.S. citizen or green card holder, and you've got a 66% ownership by two people that are. So you don't meet that 50% threshold requirement. Usually in the companies that we see, the investor, him or herself, owns at least 50%, if not 100% of their own business. So most of these investments will qualify, are very straightforward. The key when you start to bring partners into the investment, that's where you have to make sure you continue to own at least the 50%.
Mm. And so, what types of businesses qualify? Can this be something passive like a real estate investment, or does the investor need to actively be running a business?
So it needs to be an active and operational business. The consulate will like to see businesses that generate employment for U.S. workers. Other things that we use to demonstrate the fact that a business might be active or operational are things like business licenses, regular bank transactions, people coming in and out of the restaurant every day, people making sales every day, inventory purchases, equipment purchases, lease agreements, et cetera, et cetera. So those are the indications or the indicia of a company being real and operational. Real estate or rental properties usually do not qualify for E-2 visa purposes because the consulate views those as passive investments. Collection of rental income or collection or flipping properties usually is not doing business on a regular, active, ongoing basis. So when you have real estate development companies or any type of rental properties, we do analyze those in greater detail to determine whether there's some eligibility there. That usually depends on how high the investment is. If it's a multi-million-dollar real estate development that's going to take several years to develop, that might qualify because you can show that you're providing employment for construction workers, architects, civil engineers, et cetera, throughout the 5-year period. If it's on a smaller scale, potentially not. So real estate investment, we do look at very, very closely in terms of whether or not it's worth the person's time, energy, and effort to invest in those types of companies to meet the E-2 visa eligibility requirements. Usually more active and operational businesses have a much higher chance of success.
Hmm. And that leads to another practical question and a decision that people face early on. So do you generally see stronger cases when somebody starts a business from scratch or when they purchase an existing business?
Great question. I don't see any difference in terms of strength of cases. You can start a company from scratch and make your investment by individual purchases. and to get to meet your threshold requirement. Or if you like a business that's already in place, for example, a franchise or things like that, you can purchase a business that's already in place, purchase the membership interest or purchase the assets of that company and move forward with that corporate entity as your E2 vehicle. Both are very approvable. It comes down to the purchase price. If you buy a business for $50,000, you're going to have to invest more cash to meet your $120,000 requirement. So we've seen that before where they buy a business and then put in more cash, spruce up the premises, renovate, hire more people, etc. It could turn into quite a profitable venture for them that they got at a low purchase price, and now they're bringing up to a level that is valid for E2 visa issuance. I've also seen purchases of companies in the hundreds of $1,000 ranges where a company is very valuable already and they think that they can also improve it, and so they purchase a pre-existing business that comes with the payroll already in place, comes with the lease agreements already in place, etc., etc., etc. On the flip side, I've seen plenty of people invest hundreds of thousands of dollars in their own startup ideas. So equipment, inventory, premises, trade, things back and forth, et cetera, et cetera. So both are very approvable. It comes down to what's a good business decision from the investor's perspective. They need to pick ventures that have a high chance of profitability, high chance of U.S. workers. Otherwise, they'll be spending a lot of money on a business that might fail in the future, and then they won't get their E2s. Their E2s eventually will be denied, or they won't be able to continue with their business because the venture itself was not very profitable.
Mm. All right, so now let's assume that the business is already set up. What does actually running it look like from the E2 perspective? So, what are the expectations, for example, around hiring employees?
Great question. So E2 visas, there's no minimum, just like there's no minimum amount of investment, there's no minimum amount of employees that a business has to have. That being said, E2 visas, it's very clear in the regulations that they need to be ventures that provide work for U.S. workers, that provide tax payments for local economies, things like that. So the more employees that a company has, the more likely that their E2 visa will be issued, and the more likely that they will be able to renew it in 2 to 5 years, depending on when the visa expires. Usually the consulates on the first E2 visa application, they will accept a business plan, a 5-year business plan that articulates the company's financial projections for the 5 years and articulates the company's employee structure for the next 5 years. Once the person is issued their E2 visa, they come to the United States, they invest in their company, they run their business, and hopefully they can meet those expectations such that at the renewal stage, they can have a tax return, employee, payroll list, etc., that can show the consulate that they have been paying taxes in the United States, that they have been employing U.S. workers in the United States throughout the period of time. The more profitable a company is and the more work it provides for U.S. workers, the higher chance of success that the E2 visa will be renewed at a later date. Contract, oftentimes we get questions about contract workers versus W-2 employees. Both can be satisfactory. You could have a construction company that has very few individuals on their payroll on a regular basis, but they issue 100 1099 to various construction workers or subcontractors, etc., throughout the course of time. So you can still provide jobs for U.S. workers in a variety of ways. The consulate will want to see that big picture to make sure that there's an economic impact of your business in the local economy that's helping U.S. workers and generating tax revenue.
Mm. And in some cases, I'm sure the investor wants to bring in some people that they already trust. So can an E2 investor bring employees in from their home country to work in their U.S. business?
Yes, so long as the employee is of the same nationality as the investor. So for example, if you're a Canadian investor, you can bring other Canadians over to work as E2 employees. This is very attractive for individuals that already have businesses in their home countries, and they're usually setting up similar businesses in the United States. So there is a synergy of operations between the company in their home country and in the company in the United States, and they have managers or executives or people of specialized knowledge or skill set that would do very well or promote the business here in the United States, especially during those early years of growth if it's a startup. So they can transfer people that are managers, executive, supervisory people that have the same nationality, or people that have what we call essential or specialized skill sets. So you can transfer those people from your home country to the US. It still requires that person to qualify for the visa. They still need to go and apply for the visa at the consulate, and the questions that they will receive at the consulate are different than the questions that the investor usually receives. It's less about the investment, less about the company, and more about how that individual fits into the corporate structure and how that individual will fit into the corporate structure in the United States. One question that they do ask is whether that individual is bringing skill sets to the table that cannot be found in the United States. So if the US company cannot hire a US worker for those positions, then they will ask that person, let's say in Canada, for example, they'll ask that person, what does that person bring to the table that maybe can't be found by a US worker already in the US? What they don't want to see is the company, the E-2 investor, bringing over foreign workers in positions that otherwise could probably be filled by US workers. They still want the US company to hire as many US workers as possible.
That makes sense. One thing that surprises a lot of people is restrictions on earning income outside of the E-2 business. Like, is it okay for them to take a side job or consulting and generate additional income from outside?
Usually no. So the E2 employer, the E2 investor, it's an employment specific or an employer specific relationship. The visa itself is tied to the corporate entity that is actually approved by the consulate, approved for the investment. So those employees or that investor, they're only allowed to work for the E2 company while they are physically present in the United States. They cannot accept employment through other corporate entities. So we see it a lot where someone, maybe for tax purposes or restructuring purposes, they want to open new divisions within their E2 company. They want to change the corporate entity. They want to sell the business, those types of things. They need to be very cautious and have a plan in place, have a succession plan in place, or maybe even go back to the consulate, get those updates approved by the consulate before they're made so that they don't have any violations of status while they're physically in the United States. Individuals that are outside the United States, so if they maintain their consulting agreements or companies in their home countries, the employer specific rules only apply to situations where they're physically present in the United States. So if they want to continue their consulting or take income from their foreign companies at the same time, they can do that so long as they're outside the United States when they're working for those businesses. Inside the US, you're only allowed to work for the E2 authorized corporate entity.
Hmm. And of course, not every business goes exactly as planned. So, what happens if the business doesn't go well? What if it underperforms or fails, or the owner wants to sell it?
Fair question. So if the business underperforms or fails, usually we will find that out or we'll discuss those types of issues when the individual wants to go for their visa renewal. So they can make a decision at that point. You can try to apply for renewals and try to hire more people or beef up the numbers or put more money in, or go to the consulate and say, listen, this is what happened. These were the economic conditions. So during the COVID pandemic, for example, those first few years of the COVID pandemic, usually people, when they came up for their renewal, the consulates understood that maybe the numbers during the COVID pandemic were not what they needed to be or were not as high as expected because of obvious situations from the economic perspective. So they can still do ways if they want to renew their visas to try to do new business plans, try to give the reasons for maybe why the business didn't do as well as expected. It will be up to the discretion of the consular officer whether or not they still think that the business can contribute to the local economy, provide additional jobs for the US worker, etc. If the company, then the individual will just make a decision of whether or not they want to go for that visa or should they sell the business or wind down the business. We've had the opposite where a business does very well and overperforms and they get offers to purchase their company. So they will make a lot of money. It's exactly what the E2 investment is for. They invested in a business, they get an offer to purchase the business, and they're going to make a lot of money from their investment. They've run it such that it's been very attractive for another investor to come and purchase it from them. And that's great. They'll recoup their investments plus make money. So the key here in terms of whether the business is failing or doing very well usually comes down to the timing of when you would make those decisions to sell. So for example, because the E-2 visa is employer specific, you cannot make changes to that corporate entity or sell that corporate entity if the individual is in the United States in E-2 status, because the second that they sell that business, they're going to lose their E-2 status. So it comes down more to a timing issue. Does the person want to file for another E-2? Do they want to make any changes at the consulate? Do they want to switch to a different status before the sale or the winding down process begins? So if those opportunities present themselves to individuals, you want to bring your immigration lawyer into the conversation with the corporate lawyer, with the broker, anything like that at the beginning of that process, not only to get yourself the best deal in terms of selling a business that's over or underperforming, but also to get the best tax advice, and also how does it affect the immigration? Because the piece to the immigration is you don't want to be in a position where you're violating your status in any way because opportunities present themselves.
That's definitely a place where the guidance is crucial. So let's skip over for a moment. We'll shift over to talking about what it means to the investors on a personal level. What does it look like for the investor's family? Can their spouse work? Can their children attend school in the United States?
Yes, so one of the reasons why an E-2 investor visa is very attractive to business owners and individuals is that the spouse, it's one of the few visas that allows a spouse to actually get a blanket work permit or blanket work authorization in the United States. So whether the investor is the wife or the husband, the respective spouse can then go and work at any business or in any capacity that they would like to while physically in the United States. So from the family perspective, it's very attractive because it authorizes spouses to work. Also for school, it's a visa where the children are allowed to attend public school. They're not required to get school visas or F1 student visas on their own. They are included on the E-2 application up until the age of 21. So the individual's children can go to public school, can essentially even attend a few years of college before they need to switch to what's called an F1 student visa. So from a family planning perspective, it's a very attractive visa as well.
Hmm. And when people are evaluating their options, they're often comparing different paths. So, how does the E-2 investor visa compare, for example, to the EB-5 program?
Great. Yes. So we get this question quite often. So there is the EB-5 program, usually what people think of when they think of an investor visa. Usually the first thing that comes to mind is this EB-5 program, which is when an individual can invest a certain amount of money into a venture in the United States and actually apply for a green card. So an E-2 investor visa is not the same as the EB-5 investor program. The E-2 investor visa is a temporary work-based visa application that authorizes you to visit the United States, come and work for your business, run your company, and it was going to be valid from anywhere for 2 to 5 years. The investment threshold is also much lower. So the E-2 investor visa does not require a threshold investment of hundreds of thousands of dollars or millions of dollars that the EB-5 program does require. If investors want to pursue green cards in the United States, then that EB-5 investor program, if you invest a higher amount of money or you meet the thresholds for that program, you actually are applying for green card, which is not a temporary visa to the United States. It's the permanent residency visa to allow you to live and reside permanently in the United States. And it also is on a path to US citizenship in the long run. So the EB-5 investor program is usually used for individuals of high net worth that maybe are looking to have a more permanent option while physically in the United States. In terms of tax implications, usually there are tax implications for that program as well when someone comes to the United States and gets a green card. The E-2 investor visa is used more for individuals that don't necessarily want to live in the United States on the long run or don't want to spend that kind of money on ventures in the United States. They can be, family-run businesses on a much smaller scale to allow the person to come and see if this is a good venture to make money in the United States and hopefully recoup their investment and also do good business in the US. So it's a temporary visa compared to a permanent ability to live in the United States. And it usually we use the E-2 investor visa for smaller businesses that want to come and see if this is a good place where they can recoup their investment.
Hmm. And another comparison I know comes up quite a bit is how the E-2 is different from the E-1 treaty trader visa. Can you explain that?
Yeah, so the E-2 is a investment in the United States, and the E-1 treaty trader visa has very similar elements to the E-2. The E-1 would be used for a business that's based on trade. So, for example, if you're importing and exporting electronics between the United States and your home country, if you're importing or exporting stone or marble products, linens, things like that, cars, we do a lot of classic cars, import export to Europe and back, or car parts. Those import export businesses are gonna tend to be E1 qualifying businesses. The requirements are very similar, if not identical, with the exception of, instead of showing $120,000 invested in a business in the United States, the consulate would like to see about $120,000 worth of trade going back and forth between the US and the home country. So when you meet that threshold requirement, you would apply for your E1 treaty trader visa to show the consulate that, yes, over the course of 5 years, you are conducting a substantial trade already on a regular basis, and over the course of the next 5 years, you will likely continue to do that. E1 treaty trader visas are not necessarily appropriate for every inventory-based business or every trade-based business, especially if you're sourcing products from countries that are not the home country, or country that are not the United States. So E1 trade visas require that the products be sourced at least 51% between the US and the home, in the individual's home country, whether it's import, export, or a combination of both. So for example, if you're purchasing or sourcing products from China, India, things like that, that is not on the treaty list. That will not count toward a treaty trader visa. So from a global economic standpoint, with currency conversions and things like that, sometimes an E1 would not be a great choice for individuals, especially if there's going to be major shifts in currency, because it might be quite expensive to continue to source from the home country or from the US when other cheaper products are available. So we look at that on a very careful and individual basis, and we usually use E1 visas for companies that are major manufacturing facilities in their home country, and they want to export, or they want to buy raw materials from the United States. So there's already a trade pattern established. Is usually a really great choice. Is usually a great choice for them.
And to bring this all together, Mary, from your experience, what are the most common mistakes that people make with the E2 visa, and what should someone get right before they invest even the first dollar?
So one of the most common mistakes I see is that they apply for the E2 visa prematurely. They think that money in the bank is enough to have the visa issued. They usually are on a strict budget. They don't want to spend the full amount. And once if an E2 visa is denied at the consulate or by the immigration service, it's very difficult to overcome that denial, even if you later then go and invest the threshold amount of money. So usually it can be a tedious process to kind of get all the paperwork set up and ready to go. But we see the greatest success for the individuals that are patient and willing to make those commitments before they go and apply for the visa. What I would suggest to someone before they invest in a dollar, a lot of times people let the immigration piece drive the business. They choose businesses that they think have the highest chance of success from an E2 visa perspective. For example, maybe it worked for a friend, maybe it worked for a relative, maybe they've read online that these types of businesses are routinely approved, but that's not exactly what they want to do. They don't have any passions for that business. They don't have any care for that business. They're not experienced necessarily in that business type. They want to do something else. And so they might have the first visa approved, but then they get stuck. They don't really know how to run this type of business. They've never been in this type of industry before. So the business usually fails, or they don't do as well as they expect. They've spent a lot of money on a company that they're not passionate about, that they don't know how to run. So what I usually advise people is pick projects or pick ventures that you think will work best for you. What do you want to see happen? How do you run a business? Don't let the immigration piece drive the business. If you're passionate about a company or a project or an idea, and you're willing to put in the money and you're willing to work hard at it, those businesses usually do very well over the course of time. Those people usually get their E2 visas renewed at a later date because they've put in the effort, they've put in the work to that business over the course of the 2 to 5 years. Individuals that maybe just purchase a business because they think be the fastest way to get a visa. Sometimes they're not as successful because their heart's really not in it, and they've let the immigration piece dictate the business side instead of the business side dictate the immigration piece.
Mm. Well, Mary, that's incredibly helpful. If someone is watching this webcast and considering an E2, what's the best next step for them?
Great question. I think that the next best step for them is to seriously consider how much money they wish to spend on their venture. So they don't need to spend, they need to put together a budget in terms of what ideas they might have, what types of businesses they might be interested, how much will it cost to get those types of businesses started. They put together a good budget and how much money, where they're going to get their money and how they're going to fund it. And then I think once you have your budget or how much you're willing to seriously consider a business before you purchase the company or before you make any expenditures, the next step is to bring your immigration attorney in right at the beginning. We like to guide people from start to finish. It makes it a lot easier from a documentation standpoint, it makes it a lot easier from an advice standpoint. If the transactions have happened or have already happened or the businesses has already been set up from maybe last year, the year before, it makes our job a little bit more complicated trying to go back and reconstruct if any of those qualifying purchases or investment previously qualify. If you bring in your immigration attorney from the beginning and you kind of set up the whole process step by step with them in consultation, it's very easy to document the visa application for the consulate. So that's what I would recommend. Put together a budget, put together some ideas of what you're seriously considering investing in or building in the United States, and then give us a call.
Wonderful. Well, Mary, thank you so much. This has been really helpful.
Thank you for having me. Appreciate it.